because he had already served it by the time the district court ruled, he couldn't have challenged it if he wanted.
I think you're fighting the hypothetical a little bit, and I'd like to just pursue it a little bit further. So let's say he is on probation, and the probation is you cannot violate this law again, and then he brings an injunctive action under 1983 to say you cannot enforce this law to me. Wouldn't that necessarily imply and in fact preclude the courts and law enforcement agencies from enforcing that law again to him during the course of his court probation?
No, Your Honor, I don't think it would not prohibit law enforcement from seeking to enforce the terms of the probation.
The probation being don't violate this law again, the same law that he's bringing 1983 to say cannot be enforced.
That's
Even that you would say
correct,
would be permissible and not problematical under Heck.
I don't think it's problematic under Heck.
Well, let's say I disagree with you on that.
All right.
Okay. What do we do with the fact that in this case, while the probation did expire before the summary judgment ruling, it was in place at the time he filed his lawsuit? And should we be assessing Heck problems? I think there is one of the hypothetical Justice Jackson gave you. Should we be assessing Heck problems at the time of summary judgment, at the time it reaches his court, or at the time of the filing of the lawsuit?
I think in this case, certainly the time to assess it is by the time the district court had issued its order. I think my friend's argument on the other side in asking for a time of filing rule mistakes Heck, which is about when you have a cause of action for a jurisdictional rule. And of course,
So you wouldn't have a cause of action under Heck at the time you filed, but it does spring into action, and there is a cause of action by the time of summary judgment. Is that it?
In terms of when I think you would assess when Heck applies or not, I think that's when that, and I think we know that in part, Your Honor, from Wallace versus Cato, where Justice Scalia suggested that under the unusual facts of that case, one proper thing to do would be to stay the action until future action taken. If it were a time of filing rule, Justice Scalia could not have made that suggestion.
And then what do we do with the fact that your client sought damages, compensatory damages? Now, I understand he has forsworn those for us, but in his complaint, he did seek compensatory damages, which is backward-looking.
A couple of responses to that, Your Honor. I think as an initial matter, just to be clear on the record, he abandoned the damages claim in the Fifth Circuit on appeal. Even if he had not, this court takes a claim-by-claim approach.
Well, it's the same claim. It's just a different form of relief. It's still a 1983 claim, but it's just a different remedy.
Yes, and let me be clear, Justice Gorsuch. This court goes claim by claim or relief by relief, and it assesses those differently, right? So that in Balasag, for example, Justice Scalia, he barred one of the claims that was backward-looking, but remanded so that the purely prospective injunctive relief claim could go forward.
Last question, and I'll leave you alone, I promise. A win here, what if it had some collateral consequences, issue preclusion consequences, such that it would preclude, for example, the state from seeking collateral consequences for his conviction? I don't know what they might be in this case, but let's say there were some, barring him from owning a gun or whatever it might be. And your victory here would seem to preclude them from doing that, on issue preclusion, if you were to win. What do we do about that?
I think Justice Scalia anticipated just that question in Heck, Justice Gorsuch, when he made clear that the federal 1983 judgment would not, and to quote Justice Scalia, would not automatically or even permissibly preclude the state. That would be another inquiry, and there might be various grounds that a state applying federal issue preclusion rules, as the state court would do, that a state could, so that preclusion would not inevitably apply in that case.